Welcome to this webinar regarding assignments for the benefit of creditors, a vehicle that can be an effective tool for selling and acquiring distressed businesses. My name is David Kupitz. I'm a partner with the law firm Solmeyer Kupitz. We focus in large part on business reorganization, business bankruptcy, insolvency, restructuring, and related litigation and transactions, including assignments for the benefit of creditors. An assignment for the benefit of creditors, or what is frequently referred to as an ABC, is a business liquidation or transaction device. It's available to insolvent or illiquid entities. It's an alternative to a federal bankruptcy case. And what an assignment or ABC involves is a voluntary transfer of all assets of the entity that makes the assignment to an assignee to be held in trust for the purpose of liquidating the assets. Now, this liquidation may take the form of a going concern sale, and the liquidation or going concern sale is to be for the benefit of all creditors. The process of an ABC is commenced by the distressed entity, what's referred to as the assignor, entering an agreement with the party which will be responsible for conducting the wind down and or liquidation or going concern sale. That's the assignee. And the assignee acts in a fiduciary capacity, again, for the benefit of all of the assignor's creditors. There's an assignment agreement, which is a contract under which the assignor transfers all of its right, title, and interest in and custody and control of its property to this third-party assignee in trust. The assignee liquidates the property and distributes the proceeds to the assignor's creditors. In an ABC, as in a formal bankruptcy proceeding, unsecured creditors of the assignor have no right to pursue the assets assigned to the assignee, but rather they're required to submit a proof of claim to the assignee, and if the claim is allowed, will ultimately participate in the assignee's distribution of funds from the assignment estate. As I will discuss later, under the Uniform Commercial Code, the assignee has the rights of a lien creditor, and that cuts off the rights of unsecured claims. The option of making an assignment for the benefit of creditors is available on a state-by-state basis. During the meltdown suffered in the dot-com and technology business sectors in the early 2000s, California sort of became the capital of ABCs. They were done on a very frequent basis in that period, especially for companies in the dot-com and technology spaces. In discussing assignments for the benefit of creditors, this webinar will focus primarily on California ABC law, where the goal is to transfer the assets of a troubled business to an acquiring entity, free of the unsecured debt incurred by the transferor, and wind down the company in a manner designed to minimize negative publicity and potential liability for directors and management. In many instances, or at least in some cases, the right situations, the most advantageous and graceful exit strategy may be an assignment for the benefit of creditors. An ABC can be and can serve as a useful and efficient means of, one, facilitating a buyer's acquisition of a troubled business or assets from an entity burdened with unsecured debt, and with cooperation of secured creditors, secured debt. The ABC process can also be used to accomplish the wind down and liquidation or going concern sale of a distressed business unable to reorganize on its own. In some instances, an ABC can be used to maximize a secured creditor's recovery from assets of a distressed debtor. In situations where a secured creditor is simply underwater, an ABC might be the best means of maximizing secured creditor recovery. As a common law liquidation vehicle that has been around for a very long time, ABCs have been used over the years for many different types of businesses. As mentioned previously, in the early 2000s, ABCs were used at a particularly high volume for troubled dot-com and technology companies. ABCs have also been used for manufacturers, distributors, agriculture and produce companies, apparel, healthcare companies, retailers, just across the board. In large part, the use of ABCs simply reflects the distressed nature of particular industries during a business cycle. ABCs allow for quick and flexible action that frequently is necessary in order to maximize the value that might be obtained for a business that is largely dependent on the know-how and expertise of key personnel, for example, technology companies. An ABC may provide a vehicle for implementation of a quick transaction, which can be implemented before key employees jump from what they may perceive to be a sinking ship. The liquidation process in an ABC can take many different forms. In some instances, negotiations between the buyer and the assignee commence before the assignment is made. And a prepackaged transaction that both the assignor and the buyer and the assignee have all negotiated and put together is agreed on and can be implemented contemporaneously with the execution of the assignment. This type of a turnkey sale can effectively allow the purchaser of a business to acquire the business without assuming the former owner's unsecured debt in a manner where the business operations continue uninterrupted. In certain instances, the assignee may even operate the assignor's business post-ABC with the intent of selling the business as a going concern, even if a pre-ABC agreement has not been reached with the purchaser. However, in those instances, the assignee must weigh the risks and the costs of continuing to operate the business against the anticipated benefits to be received from a going concern sale. In many cases, the distressed enterprise has already ceased operations prior to making the assignment, or will cease its business operations at the time the ABC is entered. In these cases, the assignee may be selling the assets in bulk, or may sell or license certain key assets and liquidate the other assets through auctions or other private or public liquidation sale methods. Accordingly, in ABCs are also frequently used to close down and accomplish a piecemeal liquidation, not just to facilitate transactions. At all times, the assignee is guided by its responsibility to act in a reasonable manner designed to maximize value obtained for the assets and ultimate creditor recovery under the circumstances. And that leaves a lot of way frequently for discretion because the circumstances are frequently very dire and there's urgent action that is often required. Taking a look at a typical distressed transaction scenario. Typically, there's going to be a company that is burdened with debt that makes a merger or acquisition infeasible. A quick sale or an infusion of capital, whether equity or debt, is often needed, or maybe the company's lender simply wants out and is not prepared to make any additional advances. Often there is inadequate funding or a lack of desire for Chapter 11 reorganization. That lack of desire may be that Chapter 11 may be perceived to be too expensive a process, too complicated a process, too uncertain a process, and may be perceived to take too long. Certainly Chapter 11 can be the solution in many troubled situations, but also the ABC is a good alternative in a number of situations where Chapter 11 just is not a viable alternative or may just be too expensive. Often their time is limited for the transaction to be completed. Urgent action is needed. Under these circumstances, hopefully the company's board of directors has already considered the realistic alternatives available to the company. If not, it needs to do that right away. Generally, at this point, the company is insolvent. That for our purposes, that means the debts exceed the value of its assets. Frequently, the company's not paying its debts as they come due. And at that point, the board needs to recognize that under the circumstances, it has fiduciary obligations running to the company's creditors, and it is required to act in a manner reasonably designed to maximize creditor recovery under the circumstances. Among the alternatives that the board may consider include 1, merging or being acquired by a qualified candidate, 2, commencing a formal bankruptcy proceeding, whether that's a Chapter 11 reorganization case or a Chapter 7 liquidation case, 3, engaging in an out-of-court debt restructuring or workout, 4, shutting down the business and simply closing the doors. That may be viewed sort of as an informal death, whereas a Chapter 7 liquidation would be a formal burial process. 5, streamlining the company and focusing on a smaller business model or making other business adjustments. Or 6, making an assignment for the benefit of creditors. It may be that the board has determined, in a typical scenario, that a going concern sale of the company's business is in the best interest of the company and its creditors, and believes that a sale to a buyer that may have already been found by the company or an investment banker hired by the company is the best available alternative. However, generally in the distressed transaction scenario described, the purchaser is not going to be willing to acquire the business if the assumption of the company's unsecured debt is involved. Further, frequently the situation is deteriorating rapidly. The company is burning through its cash reserves. The company's key employees are aware of its financial difficulties, and creditors of the company are pressing for payment. Under these circumstances, it's imperative that the company's board seek advice, and it may conclude that an assignment for the benefit of creditors, or an ABC, is the most appropriate course of action. Let's take a step back for a minute and look at the alternative distressed transaction structures in addition to ABCs. So you have an out-of-court workout or debt restructuring as an option. That's a negotiated consensual process. In that kind of out-of-court debt restructuring, there's no ability to force unsecured creditors to waive or discount claims. And the purchaser of all or substantially all the assets of the business from an insolvent entity, if that's what's in store, is generally going to be unwilling to risk successor liability or fraudulent transfer exposure. Another alternative is a receivership. Now, receivership is a judicial process, and the court order spells out the power of a receiver. The receiver would act like a bankruptcy trustee or like an assignee in an ABC, and would be responsible, but the receiver's powers are spelled out by the court, and it's a judicial process, so you have the complications of a judicial process. In addition, generally speaking, receiverships are initiated by creditors in connection with a potential foreclosure, or by shareholders in connection with a shareholder dispute that may or may not fit the circumstances at issue, and receiverships can be a potential option to be considered, but may not be the right option in many situations. Another potential option is a foreclosure by a secured creditor if the secured creditor is underwater, or a peaceful transfer of possession of the assets to the secured creditor, again if a secured creditor is underwater. Frequently secured creditors, if there's an alternative out there like an ABC and sometimes a bankruptcy, may desire to avoid taking control and possession of assets and responsibility. That's especially the case where existing insiders may be the only likely potential purchasers. As secured creditors over recent years, and certainly since the early 2000s, have become more knowledgeable and comfortable with the ABC process, I'm seeing it implemented more frequently in situations where secured creditors are on board and supportive of the process, and are in favor of sort of the insulation that they may obtain through a third-party fiduciary, the assignee handling the disposition of the assets. Bankruptcy, of course, is another option. You have Chapter 7, which is a formal burial process, and Chapter 7 bankruptcy provides a procedure for the orderly liquidation of the assets of the debtor and the ultimate payment of creditors in accordance with the priorities set out in the Bankruptcy Code. Upon the commencement of a Chapter 7 case, a bankruptcy trustee is appointed who's charged with marshaling all of the assets of the debtor, liquidating the assets, and eventually distributing the proceeds of the liquidation to the debtor's creditors. Now, this process can take many months or even years and is governed by detailed statutory requirements. It's a judicial process where court approval is necessary for any kind of significant actions. Chapter 11 is another bankruptcy option. Chapter 11 is simply another chapter under the Bankruptcy Code, which is titled Reorganization, although frequently Chapter 11 takes the form of liquidation in the context of what are called Section 363 sales, where a going concern sale may be facilitated through Chapter 11 on an expedited basis in many instances. Chapter 11 provides this framework for facilitating a reorganization or a 363 sale. Unlike the traditional common law assignment for the benefit of creditors, Chapter 11 and Chapter 7 bankruptcy cases are presided over by a federal bankruptcy judge and are governed by a detailed federal statute. Another option that's available out there in terms of distressed transaction kind of structure is acquiring secured debt, where the buyer of the secured debt can then potentially implement a transition through any of the prior structures discussed, whether it's through bankruptcy, whether it's through an assignment for the benefit of creditors, a foreclosure, or receivership. Taking a quick look at a case study of a case I was involved in, and we had an apparel company that had done about $60 million in sales in recent years. That was its annual revenue in recent years. It had a significant amount of secured debt, operations in California and Mexico with a substantial number of employees. The company had been marketed extensively for either some kind of capital infusion, whether equity or debt, refinancing or sale. It had an investment banker that had run that process. The company's lender was refusing to make any further advances to the company and was only on a minimal basis supporting keeping the company alive in order to facilitate some sort of transaction on a very expedited short-term basis. The company was facing a liquidity and cash crisis. It really had insufficient funding for Chapter 11. Its lender was not willing to fund a Chapter 11 process, and what the lender perceived to be the cost and uncertainty of the process. Immediate action was needed to preserve rapidly decreasing value. If the company shut down, value would diminish on a very fast basis. Based on extensive marketing of the business, it became clear that the company's business and assets, both on a going concern and liquidation basis, were worth considerably less than the amount owing to the secured lender. An ABC was discussed, and the lender consented to the implementation of a transaction through an ABC. An assignee was selected. There had been several potential purchasers out there, but there was only one remaining potential purchaser standing, and that potential purchaser negotiated an asset purchase agreement with the assignee. The bank then consented to a discounted payoff. General assignment documents were prepared, so an assignment was entered contemporaneously with the asset purchase agreement being entered, and the company was sold on a turnkey basis. The loss of jobs was minimized. The value of the company was preserved under what were urgent, kind of dire circumstances, and the bank was paid off at a discount. Now, in that case, there just was no value left for unsecured creditors, but it facilitated the transition of a business and maximizing value, getting the bank significantly paid down. Commencing an ABC. It's not a particularly complicated process. There's a general assignment agreement that needs to be entered between the assignor and the assignee. Both board of director and shareholder authorization for the company making the assignment are generally going to be necessary. In an LLC or other non-corporate entity, whatever the appropriate governing authorization is going to be required. While the authorization requirement is dictated by applicable state law, an ABC constitutes a transfer of all of the assignor's assets to the assignee, and the law of many states provides that the transfer of all or substantially all of a corporation's assets is subject to shareholder approval. In some states, this approval may be obtained retroactively, but certainly it should be obtained in advance. In contrast, shareholder approval is not required in order for a corporation to file a petition commencing a federal bankruptcy case. As a result, in some instances, the shareholder approval requirement for an ABC can be an impediment to the quick action ordinarily available in the context of an ABC, especially when it's a public company that is the assignor. It's pretty unusual for public companies to do assignments for the benefit of creditors. I've been involved in a few. There are certainly quite a few small public companies out there, but that is not the norm. Usually you're going to have privately and closely held companies that are making assignments for the benefit of creditors, but I certainly have seen instances where it made sense and was utilized for public companies. Looking at governing law very quickly, ABCs originated at common law. In some states, they're now governed by statutes, and in some states, they're governed by very detailed statutes. It tends to be in those states where there's a very detailed statute, ABCs are not utilized on a frequent basis. New York is one of those states. Other states have ABC laws that are permissive, basically allowing common law assignments to continue, sometimes with a bit of a statutory gloss or framework. Usually there is. Turning to California ABC law. California ABCs are governed by common law, subject to various scattered specific statutory provisions, but it's basically a loose framework. And in states like California, where common law with some specific statutory supplements govern the ABC process, the process is non-judicial, so you're not filing a case before any court. It's a non-judicial process. The basis for applicability of common law in California is set forth in the Civil Code, section 22.2, which provides that the common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all courts of this state. In California, an assignee for the benefit of creditors serves in a capacity that is analogous to a bankruptcy trustee and is responsible for liquidating the assets of the assignment estate and distributing the net proceeds, if any, to the assignor's creditors. Both California and federal court reported decisions have recognized ABCs as long-standing and useful processes in the context of insolvency and liquidations. Now taking a look at some of the potential benefits of an ABC. Quick action, that's one. In many cases, a transaction, if that's the type of ABC that's being pursued, may be completed in weeks, so it can be done quickly. And again, as I mentioned earlier, it can potentially be prepackaged. Enterprise value may be preserved and piecemeal liquidation avoided, certainly in the prepackaged transactions. Otherwise, ABCs may be used to accomplish a piecemeal liquidation. Some of the costs and delay and complications, along with the uncertainty of a court proceeding, may be avoided. Generally, an ABC prepackaged kind of transaction is going to be quicker and less expensive than a Section 363 sale in a Chapter 11 case. That's not to say that ABCs don't have a cost that goes along with them. They do. It's just in Chapter 11, the costs tend to be more significant. In bankruptcy, the judicial process is invoked, and that brings with it additional uncertainty and complications, including certain players whose identity is unknown at the time the bankruptcy case is filed, such as if it's Chapter 7, the bankruptcy trustee, the court, you don't know in advance, generally speaking, what judge you're going to have, the United States trustee, and potentially a creditors committee in Chapter 11. So those players get introduced after the bankruptcy case is commenced. In a prepackaged ABC, where an immediate going concern sale is going to be implemented, the assignee needs to be involved prior to the ABC going effective. And that's beneficial to coordinating the process. If a company tries to do, in essence, a prepackaged Chapter 11, very difficult to do because you don't know who the Chapter 7 trustee, who's automatically appointed when the Chapter 7 petition is filed, you don't know who that trustee is going to be in advance. Further, in Chapter 7, to continue to operate a business, special court permission is needed. So Chapter 7 can sometimes be utilized to facilitate a going concern sale, but it's really not designed for that purpose, and it's very difficult to line up in advance when you don't know who your trustee is going to be. An ABC may help minimize management and directors' liability. That's because you have an independent third-party fiduciary, the assignee, who's going to be responsible for handling the ABC process, whether that's a prepackaged kind of sale transaction or a piecemeal liquidation. So the assignee, a third party, is handling the process. Further, publicity can frequently be avoided or at least minimized, since an ABC is not a public reported process like a bankruptcy case. In an ABC where a going concern sale is not going to be done, management and directors still are transferring the burden and responsibility for the wind down and the liquidation to the assignee. So that can be viewed as a benefit. On the flip side, it could be viewed as a negative in that management and directors lose control of the process once the ABC is commenced because the assignee takes over. But it should be recognized that that helps minimize potential liability and exposure, which goes along with running the process. So the assignee is in effect assuming that responsibility and the potential exposure for any issues that arise during the course of the assignment process. With secured creditor consent, sale of assets can be free of liens. In some instances, secured creditors I've seen have consented to rolling over their liens to a buyer and allowing the buyer to assume loans. Exposure on personal guarantees in the context of an ABC may be minimized or eliminated, and that frequently may be the subject of negotiation. It's also an economic reality that if you're able to maximize value, you're going to minimize the exposure on the guarantees. As a result, the common law assignment by simple transfer and trust in many cases may be a superior liquidation mechanism when compared to using what may be viewed as the more cumbersome statutory procedures governing a formal Chapter 7 bankruptcy liquidation case or a liquidating Chapter 11 case. In essence, compared to a bankruptcy liquidation, assignments may involve less administrative expense and can be substantially faster and a more flexible liquidation process. Again, and in contrast, in a bankruptcy case, you're invoking the judicial process and you're bringing in uncertainty and complications. In situations where a company is burdened with debt that makes a merger or acquisition infeasible, the management and board of the company may conclude that an ABC can be the most efficient, effective, and desirable means of effectuating a favorable transaction and addressing the debt. It's through the assignment process that the assignee is enabled to sell the assets free and clear of the unsecured debt that burdened the company. This doesn't need to be negotiated like in an out-of-court workout. Further, unlike bankruptcy where the publicity for the company and its officers and directors will be negative, and in an assignment, the press generally reads assets of Oldco acquired by Newco instead of Oldco files for bankruptcy or Oldco shuts its doors. Moreover, as previously mentioned, the assignment process removes from the board of directors and management of the troubled company the responsibility for and burden of winding down the business and disposing of the assets. Further, SEC or lender requirements obliging directors to disclose their involvement with companies that previously filed bankruptcy may not be triggered by an ABC. However, this issue requires evaluation by counsel, certainly with respect to the SEC, with securities law expertise, and is beyond the scope of this webinar. From a buyer's perspective, acquiring a going concern business or the specific assets of a distressed entity from an assignee in an ABC transaction provides some important advantages. Most sophisticated buyers will not acquire a going concern business or substantial assets from a financially distressed entity with outstanding unsecured debt unless the assets are cleansed either through an ABC or a bankruptcy process or maybe a foreclosure. And we're talking about cases where the unsecured debt is going to be left either largely or partially unpaid. So buyers in that context are generally simply unwilling to subject themselves to potential contentions that the assets were acquired as part of a fraudulent transfer and or that they are a successor to or subject to successor liability for claims against the distressed entity. Buying a going concern or specified assets from an assignee allows the purchaser to avoid these types of contentions and issues and to obtain the assets free of the assignor's secured debt. From the perspective of a secured creditor in certain circumstances, instead of being responsible for conducting a foreclosure proceeding, the secured creditor may prefer to have an independent, objective third party with expertise and experience liquidating businesses of the type of the distressed entity act as an assignee. Further, there's nothing wrong or unusual with an assignee entering into appropriate subordination and cash collateral agreements with the secured creditor and liquidating the assignor's assets and turning the proceeds over to the secured creditor to the extent that the secured creditor holds valid perfected liens on the assets that are sold and the proceeds resulting from the transaction. Accordingly, in many instances involving distressed enterprises, an assignment for the benefit of creditors may be the best means for exiting a business that has reached the end of its life cycle by minimizing negative publicity, limiting the potential liability of officers and directors, and relieving the officers and directors of the responsibility for winding down the business and disposing of its assets by entrusting that responsibility to a qualified independent professional who serves as the assignee. Additionally, the ABC process allows buyers of going concerns and specific assets to acquire them in an expeditious and efficient manner and at the same time minimize risks associated with the acquisition. Now turning to some of the disadvantages of an ABC. Well, first, there's no court order approving the sale transaction, simply the result of the reality that it's not a judicial proceeding. There is no court. An independent third-party fiduciary must agree to the transaction. So the assignee must agree to the transaction and is responsible for the ABC process. Now that can be viewed as a negative if the board and management are interested in retaining control, but it's also, as previously discussed, a major benefit, and in essence acts almost as if like an insurance policy in that the ABC process is being undertaken by the assignee who's then responsible for that process. Contracts and leases cannot be assigned without the consent of the other party to the contract. If a contract or a lease requires the consent of the counterparty, unlike in a bankruptcy case where there's Section 365 that in many instances will allow for the assignment of contracts, even if the contracts and the leases themselves don't allow it without the counterparty consent, there is no Section 365 in the ABC context. Additionally, secured creditor consent is generally going to be required to effectuate an ABC transaction at least, unless the secured creditor is getting paid in full. There's no ability to sell free and clear of liens without secured creditor consent. Again, it's not an issue if the secured creditor will be paid in full from the proceeds. And generally speaking, even in a bankruptcy context, it's difficult to do a sale free and clear of secured creditor lien, although you do have the Bankruptcy Code Section 363F that provides the basis for doing that. But unless you have the secured creditor's consent or the secured creditor is being paid in full, it's going to be difficult to even accomplish that in a bankruptcy case. Further, there's no automatic stay in the context of an ABC to prevent a secured creditor from foreclosing on collateral. When a bankruptcy case is filed, there's an automatic stay which prevents any continuing foreclosure, collection actions, litigation, anything like that. That simply doesn't exist in an assignment for the benefit of creditors. That can be an issue with respect to secured creditors, but again, you need secured creditor consent, generally speaking, to effectuate an ABC transaction. The lack of an automatic stay is generally not an issue with respect to unsecured creditors. since the assets of the entity making the assignment have been transferred to the assignee, and the unsecured creditor's claims are against the assignor, you just have an empty shell with respect to the debtor, and there's not much unsecured creditors can do in that context. In addition, the assignee holds the rights under the Uniform Commercial Code of a lien creditor, which cuts off unsecured creditor claims. One thing unsecured creditors could do is they could pursue an involuntary bankruptcy case. Anytime an entity is failing to pay its obligations on a timely basis, failing to pay its debts as they come due, there's a risk that an involuntary bankruptcy petition could be filed against it. Now, generally speaking, if the entity has 12 or more creditors, you're going to need to have at least 3 creditors signing the involuntary bankruptcy petition, or at least agreeing to sign it after it's filed. And generally, creditors are hesitant to file involuntary bankruptcy petitions because they're not looking to set up a collective forum for all creditors to share. Rather, they like to win the race to the courthouse. That being said, in the context of an ABC, experience has shown that the risk of the filing of an involuntary bankruptcy petition after an ABC is commenced is low. I've seen it happen, but it happens in a very small percentage of cases. At least that's been my experience. And frequently, when an involuntary bankruptcy petition is filed after an ABC has been commenced, the involuntary bankruptcy petition will be dismissed by the bankruptcy court because the court views the ABC as an alternative insolvency process that's already underway. And under Bankruptcy Code Section 305, the court may simply abstain from and dismiss the case. Before turning to some of the specific California law provisions that apply in ABCs, I think we should also note that in addition to the executory contracts potentially being a major issue as a disadvantage of an ABC. So for example, if you have a retailer that has many locations and has significant issues with landlords and is unable to reach agreements, unable to negotiate lease termination agreements, and otherwise has leases that it wants to assign to third parties, an ABC may not be the best solution. In addition, ipso facto default provisions that exist allowing for termination, forfeiture, or modification of contract rights based on insolvency or the commencement of an ABC are not rendered unenforceable by an ABC as they generally are by the Bankruptcy Code. Now turning to some specific California law provisions in the ABC context. California Code of Civil Procedure Section 493.010 defines an assignment for the benefit of creditors. It has to involve 1, the assignment of all the assets, 2, it has to be for the benefit of all creditors, and 3, the assignment itself is not to create a preference for a class of creditors or for a particular creditor over others. At the same time, it may recognize the preferences or priorities certain creditors hold already separate from the ABC process. There's a notice requirement for California ABCs where within 30 days of the making of the assignment, a notice needs to go out to creditors that an assignment has been made and that they're to submit their proofs of claim if they want to participate in any distribution from the assignment estate. And they need to be provided at least 150 days and not more than 180 days notice of the deadline or bar date for submitting claims. That's under the California Code of Civil Procedure. The California Code of Civil Procedure also provides for the termination of any attachment or temporary protective order liens that were obtained within 90 days prior to the making of the ABC. Certain priority provisions are provided for wage and tax claims and for a few other types of claims, but there's not a comprehensive priority statute scheme that you would have in a bankruptcy case, so it becomes a little bit more complicated in some instances. An assignee has the right to occupy business premises for 90 days, even if there was a pre-ABC default, as long as the lease wasn't terminated ABC prior to the ABC being commenced, and that's under California Civil Code section 1954.1. And again, as previously mentioned, the assignee holds the rights of a lien creditor under the Uniform Commercial Code, or in California, it's the California Commercial Code, and that allows the assignee to take priority over unperfected security interests and to cut off unsecured claims. Considering the distribution scheme in an ABC for a moment, under California law, as mentioned, the assignee has to set a deadline for the submission of claims. Once the assets have been liquidated and any claims submitted have been evaluated and resolved, the assignee then turns to making distribution. Generally, California law ensures that taxes, both state and municipal, and certain unpaid wages and other employee benefits and customer deposits to a certain limited extent are paid before general unsecured claims. However, particular care must be taken by assignees in dealing with claims of the federal government. And there's a catch-all type of statute under federal law which entitles any agency of the federal government to enjoy a priority status for its claims over the claims of general and unsecured creditors. The practical result of this, because the federal statute provides that paying any part of a debt of a person or a state before paying a claim of the government is anybody who does that. If the assignee does that, the assignee may be liable to the extent of the unpaid claims of the federal government. What that results in, practically speaking, is that amounts owing to the federal government are generally going to be prioritized over and above all other obligations after the secured debt. In California, again, there's no comprehensive priority scheme for distributions from an assignment estate. There's various statutes which assignees need to look at and be aware of in connection with making distribution to priority claimants, and that includes taxes and priority labor wages, lease deposits, and certain other types of claims. The order of priority among the various priority claimants, while it might not be clear, it becomes academic if there's adequate proceeds to pay all of the priority claims in full. If there aren't, then they need to be paid in order of their priority, and that issue has to be closely examined. Secured creditors, of course, retain their liens on collateral and are entitled to receive the proceeds from the sale of their collateral up to the extent of the amount of their claims, unless they agreed otherwise. If there are insufficient claims to pay, insufficient funds to pay general unsecured claims in full, and the general unsecured claims get paid after the secured debt and after the priority unsecured claims, then these claims will be paid pro rata. If unsecured claims are paid in full, equity holders will get to receive distribution in accordance with their liquidation rights. And I have seen a number of ABCs where they're, after the liquidation process, whether a going concern sale or otherwise, there were adequate proceeds to pay all of the debt, and the distribution to shareholders was made. Of course, the assignee shouldn't make any distribution to general unsecured creditors until the assignee is satisfied that all priority claims have been paid in full. And the same thing goes, the assignee is not going to make any distribution to shareholders until the assignee is satisfied that all creditors have been paid in full. Now, there's certain limitations on state law. For example, state laws may not provide for a discharge of debt or condition a creditor's participation in distribution on granting a discharge. There is no discharge in an assignment for the benefit of creditors. The company that makes the assignment is simply left as an empty corporate shell, generally speaking, it's just left floating out there. It will not pay its annual franchise tax and will become a disqualified corporation. Is just left as an empty corporate shell. Occasionally, the assignor will want to dissolve, but that potentially brings on issues regarding if creditors aren't paid in full, for representations that have to be made in that process, and almost always, unless all debt is paid in full, which is relatively unusual, if not very unusual in an ABC, the corporation is just going to be left floating out there. State law discharge provisions are preempted by the federal government's exercise of its power to enact uniform bankruptcy law. So under the Constitution, you've got the bankruptcy clause and the supremacy clause of the U.S. Constitution, and on the subject of bankruptcy, issues that go to the core of bankruptcy, that's for the federal government, and that has been perceived to include a discharge. Now, when you look at bankruptcy, you'll see that in Chapter 7 for legal entities, there is no discharge. An individual can get a discharge in Chapter 7 and get a fresh start, but there is no discharge in any event for corporate entities in Chapter 7. So if an entity files Chapter 7, it also just sits out there as an empty corporate shell. It does have the formality of having commenced a formal bankruptcy case under federal law. And in most Chapter 7 liquidation cases, there's not going to be the ability to get a discharge because Congress perceived that there would be an evil in allowing for the trading of empty corporate shells, and therefore does not allow in a Chapter 11 liquidation, I should say, for any kind of discharge under the Chapter 11 liquidating plan. In a decision that has been rejected by other courts, including California Courts of Appeal and including district courts in a number of states, the Ninth Circuit, in a case called Sherwood v. Lycos, held that the preference avoidance provision under California ABC law was preempted and unconstitutional. So California ABC law allowed for the recovery of preferential transfers. It still does, just like the bankruptcy code. And under California law, there was a statute that paralleled the preference provision in the bankruptcy code. In this surprising decision in the Sherwood Partners v. Lycos case, the Ninth Circuit Court of Appeals held that the preference avoidance provision under California ABC law was preempted by federal bankruptcy law. It held that, it asserted in the decision because both shared the goal of equitable distribution to creditors of the debtor, and in a divided decision, the Ninth Circuit's majority theory was because the right to void preferences was granted by state law to the assignee, but not to an individual creditor. The state law, quote, trenched too closely, close quote, on the federal bankruptcy power, which preempted the state law. Now, there was a dissenting opinion, and there's been various other cases that have elected not to follow the Ninth Circuit's decision, and in fact, who have said it was incorrectly decided and not properly supported, including California appeals courts in published opinions. The Sherwood v. Lycos case was a case where there was diversity jurisdiction that gave federal court jurisdiction, and the preference action that had been filed in state court was therefore moved to the district court, where the district court granted summary judgment in favor of the assignee, and in this Ninth Circuit decision, that was reversed. It really hasn't had much impact on the ABC process and how ABCs have worked, but it has led to a number of decisions which have criticized both the reasoning and the conclusion reached by the Ninth Circuit. And in taking a look at those decisions, two of them are from California state appeals courts, two are from U.S. district courts for the Eastern District of Wisconsin. There's another decision from the Western District of Wisconsin, and then there's some decisions out of Delaware, federal courts. So basically you've got a situation where the Ninth Circuit came out with the decision that has been soundly rejected. Now, it doesn't have much impact. The Ninth Circuit recognized in that same decision that ABCs are a long-standing, and they use the term venerable process that has been recognized by the U.S. Supreme Court, among others, as a viable and beneficial option to be considered and utilized in the context of insolvency and liquidations. In summary, assignments for the benefit of creditors can be particularly useful when fast action in distressed transaction and/or industry expertise is needed in order to capture value from the liquidation of the assets of a troubled enterprise. ABCs also are frequently very beneficial where a lower public profile is desired for this process. So in contrast to a bankruptcy where you're going to have public record and where you're going to have a lot of press picking up on that public record, you can frequently keep the ABC process, if desired, less public. There's no public record in California, and lower profile. In many instances involving deteriorating businesses, management engages in last-ditch efforts to sell the business in the face of mounting debt. However, frequently the value of the business is diminishing rapidly as key employees leave. The ABC process can frequently facilitate very quick action, quick transactions. You do have the issue that the assignee needs to be comfortable with facilitating and implementing the transaction, because ultimately it's the assignee's neck that's on the line. It's the assignee that's taking responsibility for effectuating a transaction and/or an ongoing liquidation process, but the issue comes to a head in connection with transactions. Therefore, when you're going to do an expedited transaction, it's important, if possible, to bring the assignee in as early as possible to allow appropriate due diligence to be done. In a situation like the apparel company scenario discussed earlier, where an investment banker has been in place for the company for a significant period of time and has been running a sale process and has been looking at other alternatives, the assignee can take advantage of that history and be able to come to a very quick conclusion frequently about a transaction as far as whether it's the best or transaction available under the circumstances, under what are often very urgent time constraints. However, if an assignee is brought into a situation and asked simply to bless a transaction and has no way to assess the reasonableness of the transaction, it becomes a more difficult situation, and that's multiplied where the part of the purchaser under the transaction may involve insiders from the company. Now, frequently, especially in small business scenarios, parties who have been involved with the company, oftentimes insiders, may be involved with the purchaser because those may be the type of people who really have an interest in the assets that are at issue in this business, especially in the distressed transaction scenario. So there's nothing by definition that makes it inappropriate for insiders to be involved on the other side of the transaction. However, it does bring on a higher level of scrutiny, and in those transactions in particular, it's important to provide the assignee with as much ammunition as possible to be able to support the transaction and to allow the assignee with as much time as is possible and feasible to be able to do some due diligence on his or her own to be comfortable in supporting the transaction. In many instances, especially in circumstances where the expense of a Chapter 11, Section 363 sale may be unsustainable, where you have deteriorating value in the assets of business that has an ongoing concern value of some sort that you're trying to capture. An assignment for the benefit of creditors can be a viable solution. Again, it also can simply be the solution as an alternative to a formal burial process in a public Chapter 7 case. So an ABC can also be used to facilitate the liquidation of the company. Thank you for joining us on this webinar regarding assignments for the benefit of creditors. Please feel free to email me with any questions that you may have. MCLE materials will be included in an email that will be sent later today or tomorrow to those who joined, and look forward to connecting with you in the future. Thank you.